People will often ask me to explain the difference between a Chapter 7 bankruptcy and a Chapter 13. A Chapter 7 is what most people refer to as a straight bankruptcy or a complete bankruptcy or a liquidation bankruptcy. Chapter 7s usually last about 4 months from the time the bankruptcy petition is filed with the court until the time the case is over with. What happens in a Chapter 7 case is the bankruptcy court appoints a trustee who's an officer of the court. And the trustee's job is to investigate and review the information that's in your bankruptcy petition to make sure that it's correct. In a Chapter 7 case, debtors usually have two different types of debts: secured debts and unsecured debts. Secured debts are debts for which you owe to a creditor who has a lien on your property, like a mortgage company has a mortgage lien on your house, and a car finance company has a lien on your car. Unsecured debts, on the other hand, are owed to creditors who don't have a lien on your property. Typically, unsecured debts would be like credit card debts, medical bills, signature loans, deficiencies that are owed after a house has been foreclosed upon or a car has been repossessed, or a breach of an apartment lease. The bankruptcy laws allow you to protect or keep or exempt certain property from the claims of your unsecured creditors, and that property is referred to as exempt property. But if you own over that level of property, the excess property is referred to as non-exempt property. In a Chapter 7 case, the bankruptcy trustee takes any non-exempt property, if there is any, and he sells it, and he uses that money to pay those unsecured creditors. Now, what you're entitled to exempt or protect depends on the laws of the state where you've resided for the past 2 years. Each state has their own set of exemptions, and the federal laws have their own set of exemptions. Now, if you haven't lived in the same state for the past 2 years, in most cases, the federal exemption laws apply. But if you've lived in North Carolina for the past 2 years, then the North Carolina exemptions will apply to you. Under the North Carolina laws, people are allowed to exempt or protect up to $35,000 of equity in their residence. Of course, if a husband and wife are both filing bankruptcy, then these exemptions double. In addition to that, you can exempt or protect up to $3,500 of equity in any one automobile. Again, the husband has a $3,500 automobile exemption and wife has one too. In addition to that, you're allowed to exempt or protect a certain amount of household goods. It's $5,000 for each debtor plus $1,000 for each dependent. In other words, if a husband and wife are filing a joint bankruptcy and they have 4 dependents, they can exempt or protect a total amount of $14,000 in value in household goods. Most retirement accounts are also exempt or protected. You can protect 401k plans, IRAs, and pension and profit sharing plans as long as they're tax qualified plans. Then in addition to all of that, you get a final exemption, and it's called a wild card exemption. The wild card exemption is $5,000 in value that you can use to protect anything that you want to protect. And you can also put your wild card exemption with any other exemption. In other words, if I had an automobile that was worth $8,000 and I didn't owe anything on that automobile, I could protect it or exempt it by using my $3,500 automobile exemption plus $4,500 of my wild card exemption. If I put those together, I can protect all the equity in the car. Now, if I don't own any non-exempt property, then the trustee doesn't take anything and sell it to pay my unsecured creditors. Now, secured creditors are treated differently. Again, they're the ones who might have a lien on your property, like a mortgage company has a mortgage lien on your house. The way secured creditors get treated in a Chapter 7 case is, if you want to keep the property that secures your debts from the creditor who has a lien on that property, then you have to be current and stay current on your payments. If you're not current, or if you don't stay current, then the secured creditor has a right to take their property back and sell it, but you don't owe them any more money. In other words, if I file a Chapter 7 and I'm not current on my car payment, my car finance company can get court permission to take the car back and sell it. But if there's a deficiency that's owed after they sell the car, then the balance of what I owe them gets wiped out in my Chapter 7 case. Now, there are certain debts that people cannot wipe out in bankruptcy. People can't wipe out student loans, most types of tax debt, alimony or child support, debts arising from drunk driving or fraud, criminal restitution, and debts that have been run up shortly before you file bankruptcy. In other words, if someone goes out and they run up their credit card debt just before they file bankruptcy, they might have a problem wiping that debt out. Now, that's basically how a Chapter 7 works. Most people who file Chapter 7s are people who fall into one of two different categories. It's usually someone who's either current on their house payments and they're current on their car payments, and they can handle those debts. They don't have a problem with that. But what they have a problem with is they have a whole lot of unsecured debt, like credit cards or medical bills, and they want to wipe out the unsecured debt, and they want to keep their house and car by keeping their house and car payments current. Or the second type of person that might file a Chapter 7 is maybe someone who's not current on their house payments, or they're not current on their car payments. And they've come to the realization that they can't afford those payments anymore. They want to give up the house, or they want to give up the car, and they want to walk away from that debt. But they're just afraid that if they don't do anything and they let the mortgage company foreclose, then after the house is foreclosed upon, if they still owe more money to the mortgage company, then the mortgage company is probably going to sue them to collect that debt. So they want to do a Chapter 7 and give up the house or give up the car and walk away from that debt too. Now, some people have a different goal. Some people are behind on their house payments or they're behind on their car payments, and they don't want to lose that property. They want to try to save their house from a foreclosure or save their car from a repossession. For those people, a Chapter 7 won't help them. A Chapter 13 might help them. A Chapter 13 is basically a debt consolidation program. For the most part, all of your debts get put together into one monthly payment, and you pay a bankruptcy trustee each month. And he takes that payment and he divides it up, and he pays your creditors a certain amount based on what they're entitled to receive under the bankruptcy laws. Now, when you file a Chapter 13, that repayment program lasts for 60 months or 5 years. The amount that you pay the trustee each month is determined by a whole lot of different factors, but it's determined primarily by how much you owe your creditors and by what type of debt it is. And there's 3 types of debt. There's secured debt, which again is like a mortgage debt or a car finance debt. There's unsecured debt, like credit card debts and medical bills. And then there's what's called priority debt. For the most part, priority debt is income tax debt. When somebody files a Chapter 13, the general rule is the tax debt gets paid back in full over the course of the 60-month period. In other words, let's say I owed the IRS $9,000. If I'm filing a Chapter 13, then each and every month when I pay the trustee, he's going to take $150 of my payment and he's going to send it to the IRS. That way, by the time my case is over with, 60 months from now, the IRS has received 60 disbursements of $150 each, which is $9,000, which is payment in full. Now, on mortgage debt, the general rule is, in a Chapter 13 case, my regular monthly mortgage payment has to get paid through my payment to the trustee. So if my mortgage payment is $1,000 a month, each and every month when I pay the trustee, he's going to take $1,000 of my payment and he's going to send it to the mortgage company. Now, if I'm behind on my mortgage payments, whatever amount that I'm behind has to get caught up over the 60-month period. Let's say, for example, I was $12,000 behind on my mortgage payments. Then when I do a Chapter 13, the trustee is not only going to make my regular monthly mortgage payment to the mortgage company, but he's going to pay him an extra $200 a month for the 60-month period, so that at the conclusion of my case, the $12,000 that I was behind when I started has now been caught up. Now, if I owe on an automobile finance debt, if I've purchased the automobile within the past 2.5 years, I have to pay back the total amount of that debt with interest over the 60-month period. Let's say, for example, I owed $20,000 on a car loan, and I've purchased the car during the past 2.5 years. In that case, I have to pay back the full amount of $20,000 with interest over the 60-month period, which is roughly about $360 a month of my Chapter 13 plan payment is being paid to my car finance company. Now, if I purchased the automobile more than 2.5 years ago, I get a little bit of a break. Instead of paying back the total amount that I owe, I get to pay back the lesser of the amount that I owe with interest or the value of the automobile. In most cases, the value of the automobile is going to be less than what I owe on the debt. Now, on unsecured debt, which is credit cards and medical bills, in a Chapter 13, those creditors have to get paid back over the course of the 60-month repayment program at least as much as what they would have received if I had filed a Chapter 7 instead. So in a Chapter 13 case, the trustee has to stop for a moment and ask himself, if this person had filed a Chapter 7, is there any property that the person owns that would have been taken away and sold by the Chapter 7 trustee because that property had so much equity in it that it exceeded what they were allowed to exempt or protect under the bankruptcy laws? And if so, how much would the unsecured creditors have been paid in that Chapter 7 case? Whatever amount that is, if you're doing a Chapter 13, the Chapter 13 trustee does not sell that property, you get to keep it. But in exchange for that, over the course of the 60-month repayment program, your unsecured creditors have to get paid back at least as much as what they would have gotten if the property had been sold in a Chapter 7. Now, if an attorney like myself knows everything about your debt, how much you owe your creditors and what type of debt it is, and what type of property you own, and what that property is worth, and how much equity you have in the property, we can sit down and calculate what would your Chapter 13 bankruptcy payment have to be in order for you to comply with what the bankruptcy laws require you to pay back to your creditors. Now, once the amount of that payment can be determined, the next question is, can you afford the payment? So in order to qualify to do a Chapter 13, you have to be able to prove to the court that you have enough income coming in each and every month that you can afford to pay all of your monthly living expenses, which would be things like your electric bill and your natural gas and your water bill and telephone and cell phone, cable television and food and clothing and gas for your car and automobile insurance, and still have enough left over to afford that Chapter 13 bankruptcy payment. So when you file bankruptcy, you provide the court with proof of what your income is. The court looks at all of your pay records for the past 6 months. And from that, they subtract your living expenses to see what you have left over. And that's what's called disposable income. If your disposable income is sufficient to be able to afford to make your Chapter 13 bankruptcy payment, then you do qualify to do a Chapter 13. But if it's not sufficient to make that payment, then you wouldn't qualify to do a Chapter 13, and the only bankruptcy option then would be a Chapter 7. Now, most people who file Chapter 13s are usually people who are trying to save their house from a foreclosure or their car from a repossession. Or they might be someone who has so much equity built up in property that they own that they're afraid of losing that property in a Chapter 7, so instead they're doing a Chapter 13 and protecting that property and paying back the equity over a period of years. And that's basically the difference between a Chapter 7 and a Chapter 13.